Welcome back, my friends, to the TBF show. Today we're going to be discussing political and judicial activism. Over the past few weeks, Democrats in at least 32 states have now challenged former President Donald Trump's eligibility to appear on primary ballots. So far, Colorado and Maine have taken the lead in these efforts. These activists are using the insurrection clause as the excuse to remove a man that they fear from the political system, thus denying tens of millions of voters their chance to vote either for or against this man. Now, this is a very dangerous precedent that we are setting here. So let's take a look at this and see what sort of validity, if any, there is. To do that, let's start with the Colorado Supreme Court, who on December 19th of 2023 ruled by a 4-3 party line vote that based on this insurrection clause, President Donald Trump would be ineligible to run for president and therefore ordered him off the primary ballot. In the conclusion of their 133-page majority opinion, the justices said that Trump's January 6th speech was a call to imminent violence due to his statements that his supporters are, quote, allowed to go by very different rules, and if they don't fight like hell, they won't have a country anymore. Now, all of this was set up by a lower court that initially ruled on this matter in Colorado by District Judge Sarah B. Wallace. Judge Wallace found that former President Donald Trump engaged in insurrection for his role in the January 6th Capitol riot, but allowed him to stay on the ballot, stating that a president is not among the officials subject to disqualification under the insurrection clause of the 14th Amendment. Of course, by ruling this way, anyone with half a brain could see that this was just a setup to hand off the ball to a higher court to further the agenda. And of course, it happened. And so, the Colorado Supreme Court, after agreeing with the trial court that Trump had committed insurrection, ruled that this lower court was wrong in its decision that Section 3 did not apply to the position of president. Now, worth noting here, in a key part of the ruling, often ignored in the media, the Colorado High Court stayed their ruling until January 4th, one day before the deadline to finalize the primary ballot. In the words of the opinion, they wrote that, if review is sought in the Supreme Court before the stay expires, it shall remain in place, and the Secretary will continue to be required to include President Trump's name on the 2024 presidential primary ballot until the receipt of any order of mandate from the Supreme Court. And since the Colorado Republican Party appealed the decision on December 27th, Trump will actually stay on the ballot. For now. Now, the other thing that most media outlets also overlooked was the dissenting opinions. There, they focused on the fact that there have been no criminal charges or conviction for insurrection, and that Trump was not allowed adequate due process. So that's the first act. The second would be up in the state of Maine, where on December 28th, so just a couple of days ago, the Secretary of State, Shenna Bellows, issued a decision holding that Trump had in fact committed an insurrection and that therefore he should not be on the primary ballot. As with the Colorado decision, legal challenges are likely to keep this action from actually taking effect for some time. So let's take a look at what happened here. Well, according to Bellows' office, on December 15th, a hearing was held to consider several challenges to Trump's ability to remain on the ballot. Importantly, and unlike in Colorado, though, this was not a court hearing, but an administrative forum, and no court has yet weighed in on the matter in that state. This means that there was even less due process than in the Colorado case. In defense of her decision, Bellows offered the following. She said, "I conclude that the record establishes that Mr. Trump, over the course of several months and culminating on January 6th of 2021, used a false narrative of election fraud to inflame his supporters and direct them to the Capitol to prevent certification of the 2020 election and the peaceful transfer of power. I likewise conclude that Mr. Trump was aware of the likelihood for violence and at least initially supported its use, given he both encouraged it with incendiary rhetoric and took no timely action to stop it. Mr. Trump's occasional request that rioters be peaceful and support law enforcement do not immunize his actions. A brief call to obey the law does not erase conduct over the course of months, culminating in his speech on the ellipse. The weight of the evidence makes clear that Mr. Trump was aware of the tinder laid by his multi-month effort to delegitimize a democratic election, and then chose to light a match." She went on to say that she would suspend the effect of her decision until the Superior Court rules on any appeal or at the time to appeal is expired. Now, Trump was given 5 days to request a trial court review, and likely the matter will work itself up to the U.S. Supreme Court. As for Trump's view on the matter, his spokesman Steve Chung has asserted that Bellows, a former ACLU attorney, is a, quote, virulent leftist who decided to interfere in the presidential election. And it went on to say that Democrats in blue states are recklessly and unconstitutionally suspending the civil rights of the American voters by attempting to summarily remove President Trump's name from the ballot. So these are the current moves on the chessboard, and all that's at stake here is the very future of our representative republic. So what about that 14th Amendment? Let's discuss. The U.S. Senate passed the 14th Amendment to the U.S. Constitution in 1866. It needed approval by at least 28 of the then 37 U.S. states to be ratified, and this would happen in 1868, just 2 years later. The amendment granted citizenship to former slaves and said that all citizens were entitled to equal protection under the law. But what is most important here for our conversation is this. Intending to limit participation in government by Confederates, this amendment, Section 3, also said that no one may, quote, hold any office, civil or military, under the United States or under any state, if they had previously taken on an oath as an officer of the United States to uphold the Constitution and thereafter engaged in insurrection or rebellion against the nation. You see, and this is really important here, this was introduced just 1 year after the American Civil War had ended. The total number of deaths in the American Civil War is estimated to be somewhere between 620,000 and 750,000 soldiers, making it the deadliest military conflict in American history, and this figure includes both Union and Confederate soldiers. And this doesn't even count the number of civilian casualties, which is undetermined. Some research suggests that the number could be as high as 850,000, but this claim is not universally accepted. The point is, over 1 million Americans had died in this conflict, or insurrection if you like. To compare this to the protest on January 6th is frankly absurd. You see, not only has former President Trump not been criminally convicted for this supposed insurrection, but if we look at actual events on January 6th of 2021, Donald Trump was tweeting to his supporters to remain peaceful during the Capitol riot. Now, for comparison here, let's talk about another incident that happened earlier in 2020. How many of you remember the hate groups like Antifa and BLM, and specifically, for this example, the George Floyd riots? Well, let me refresh your memory in case you forgot. During this period of civil unrest following the death of George Floyd, rioters caused significant damage across various U.S. cities. There was vandalism, arson, and looting that occurred between May 26th and June of 2020, which resulted in approximately $1 to $2 billion in damages nationally. This, by the way, is the highest amount ever in recorded damage from a civil disorder in U.S. history, surpassing the record set during the 1992 Los Angeles riots. It got so far out of hand that there were reports of President Donald Trump being moved to a secure bunker in the White House, with hundreds of protesters gathered outside. Some of them were throwing rocks and tugging at police barricades. I'm sure some of you remember this. And let us not forget the attempts to burn down St. John's Episcopal Church located at Lafayette Square near the White House in Washington, D.C. In fact, to this day, the Bureau of Alcohol, Tobacco, and Firearms and Explosives, or the ATF, is still seeking information leading to the identification, arrest, and prosecution of the persons responsible for this fire. And they're offering a reward of up to $25,000. And during all of this, mind you, there were at least 25 people who were either murdered or killed, and they were a mixture of rioters, bystanders, and law enforcement officers. And all of this occurred under various circumstances related to these riots and protests. Now compare this to January 6th. The Capitol riot resulted in physical damage to the Capitol building itself. The architect of the Capitol initially estimated the cost of damage was roughly about $30 million, which included damage to statues, murals, historic benches, and original shutters. And as for fatalities, there was just one, caused by the riot, which was Ashley Babbitt, a 35-year-old Air Force veteran who was fatally shot by a Capitol police officer while trying to climb through a door near the House chamber. Now, you might remember that there was another casualty, a Capitol police officer, one Brian Sicknick, who died the day after the riot. Originally, there were reports that tried to paint his death as caused by being overpowered by rioters, but that turned out to be a lie. His cause of death was later determined to be natural, and it was caused by strokes. And this, by the way, doesn't even begin to cover the new January 6th videos that had been released only a few months ago. This was done so by House Speaker Mike Johnson in November. He began making public video footage from the January 6th attack on the U.S. Capitol, stating that truth and transparency are critical. Now, some of the newly released footage has been interpreted as showing law enforcement officials helping the rioters storm the Capitol. For instance, one video shows a Capitol rioter in handcuffs being escorted, but later being released and is seen fist-bumping police officers. To be fair, and let's be fair here, it is important to note that the Capitol Police are denying the allegations that their officers helped the rioters and acted as tour guides. So to sum all of this up, we have political activist judges in Colorado and the Maine Secretary of State, Ballot, using the J6 incident, even though there is still no criminal conviction or charges of insurrection to President Donald Trump, as the excuse to take away the rights of millions of voters by removing their right to vote for or against this man. These individuals are risking the very soul of our representative republic by their actions here. The idea that the 14th Amendment was even meant for this is absurd at best. But see, I believe that these judges do know better. These judges are acting as nothing more than political activists while masquerading as judges. This is all about moving the ball forward in their never-ending quest to get Trump. You know it's bad when even fellow Democrats in our own state are deeply concerned about this move. For example, the New York Post reported back on December 29th that one of Maine's 2 Democratic members of the House of Representatives ripped his state Secretary of State for unilaterally removing former President Donald Trump from the 2024 Republican primary ballot. He said, "I voted to impeach Donald Trump for his role in the January 6th insurrection. I do not believe he should be reelected as President of the United States. However, we are a nation of laws. Therefore, until he is actually found guilty of the crime of insurrection, he should be allowed on the ballot." And Golden wasn't alone here. He was joined in his criticism of the Secretary of State by Senator Angus King, who is an independent who caucuses with the Democrats in the upper chamber of Congress. You see, my friends, the peaceful coexistence of battling ideological beliefs has been the bedrock of the United States, and it is critical for the security of our future as a country. People remain peaceful because there is the belief that even if you lose an election, you can always win next time. Taking away the rights of citizens to vote for the candidate of their choice puts all of that at risk. Recklessly stripping citizens of this fundamental right can only lead to an erosion of trust in political institutions, increased political polarization, and potential for civil conflict. It is unbelievable that we are standing on a precipice as a country, with the ultimate outcome depending on the legal process that follows here. And make no mistake, these people know this. But they don't care. They just don't. Most people have experienced upper management at companies, especially corporate entities, where they just don't care what happens. They don't care how much damage is inflicted as long as they get their paycheck, as long as they're fine, the rest of the company can burn. That's exactly what's happening here. These people don't care what happens to the country as long as they get theirs. This is how you get people like Congressman Jamie Raskin, for example, who is insisting that the Supreme Court Justice Clarence Thomas should recuse himself from the case involving Donald Trump's primary ballot access. Why? Well, he is arguing that Thomas is not qualified to decide the case because of his wife's support of the claims that the 2020 election was stolen. As he put it on CNN's State of the Union, he said, "I think anybody looking at this in any kind of dispassionate, reasonable way would say if your wife was involved in the big lie in claiming that Donald Trump had won the election and had been agitating for that and participating in the events leading up to January 6th, that you shouldn't be participating. He absolutely should recuse himself. The question is, what would we do if he doesn't recuse himself?" That last little sentence right there is a thinly veiled threat. It's obvious that this is an attempt at pressuring the Supreme Court to just give in. Again, this is a person who just doesn't care what happens to his country. It doesn't matter what damage can be done by following through with this. And so here we are. 2024 is shaping up to be perhaps one of the weirdest years in recent memory that we've had here in the US. Of course, though, only time will tell. And that, my friends, will bring our episode to a close once more. As always, my friends, thank you so much for joining me today. From the TBF channel, I am Adrian, and I will see you all next time.